Welcome to A State of Mind, Law, Legacy, and Life with Sunny.
Hello and welcome back to A State of Mind, Law, Legacy, and Life with Sunny, Principal Attorney at Rickard Law, APC. Sunny helps families and business owners in California and around the world protect what they've built through thoughtful, personalized estate planning. I'm Kevin Rosenquist, and today we're talking about how estate planning changes when family, assets, or business interests cross international borders and what families should know before they make that move. Sunny, it's great to see you.
Good to see you again, Kevin.
I know you've helped families from many different countries plan their U.S. transition. Can you share a story or perhaps even a common situation that shows just how complex cross-border planning can get?
Absolutely. One common scenario, I think, is when one family immigrates to the U.S. but still owns properties or businesses in overseas. For example, I once helped a family who had a family home and the rental properties in San Diego, a factory in Shanghai, and the investment accounts in Hong Kong. And each place has completely different property transfer laws, tax rules, and required proceedings. So to this family, a comprehensive state plan with revocable and the irrevocable trust, coordinating with the U.S. and offshore entities is essential to align everything together and ensure a smooth transition, and also to avoid a plan accidentally conflicts with other plan. So this has really showed how layered cross-border planning that can be. You really need to consider different pieces and try to make them work with each other and filling into a plan that works for everybody.
hmm Yeah, definitely. I can see how that would add a level of complexity. When people have property or relatives in more than one country, what do you feel like is the biggest misunderstanding about how those assets will transfer?
I think the biggest misconception is thinking a US will, a US trust, automatically controls everything worldwide. It doesn't.
hmm
Most countries have their own inheritance laws, inheritance courts, procedures, and restrictions, especially the civil law countries where the forced heirship rules apply. So, U.S. trust may work beautifully in California, but it means nothing in the official overseas.
hmm
People are often surprised to learn that every country involved may need different process unless the plan is coordinated from the start. Means that every pieces, like the property's location, the heir's location, your citizenship, your residency, those pieces has to be all considered to make that plan work.
What all does international estate planning really involve beyond just the basic documents?
The international estate planning is part legal, part tax, and part logistics. Yes, we created documents like the trust, like the wills, but we also look into the visa status, the residency, the foreign succession laws, the currency control rules, the tax treaties, the foreign bank reporting requirements, and the cross-border transfers. A big portion of cross-border planning is to make sure the asset titled overseas can actually be transferred without violating the local rules. It's less about the setting up the documents and it's more about understanding how the multiple legal system interact. Many times consulting with the legal counsel or the professionals is necessary.
Yeah, the tax stuff changes everything too, because I mean, how do different tax systems or reporting rules affect how the plan needs to be structured?
Yeah, it's pretty much like a concert, like orchestra, right? Have
Hmm.
different instruments, and that you really need to uh, make this all the instruments, all the parts work together, so it create a beautiful symphony. So maximizing the tax benefit is often one of the biggest drivers of the strategies. The U.S. tax worldwide assets once someone becomes a U.S. resident. Maximizing tax benefit is often the biggest driver of the strategy. The US tax worldwide asset once someone becomes a US resident, while many countries only tax local asset. Then the US also have reporting rules like FATCA, like FBAR, and the foreign trust filing requirements. So families with foreign companies or accounts, these rules can completely change how we design the plan. Sometimes we need a separate trust for the U.S. asset and the foreign assets, and sometimes we need restructured ownership before the transfer to avoid unexpected tax exposure.
Wow, there's a lot more moving parts in an international plan. You were right about the symphony for sure, the
It's
orchestra.
definitely have a lot more moving pieces when you're talking about the cross-border state planning.
Absolutely. Yeah, that's a lot. I can't believe you can keep all that in your head, that you know all this stuff, but I'm sure each one is its own unique situation, though, huh?
Yeah, that's definitely true.
For anyone listening who might be preparing to move to the US, what are some timing mistakes that you've seen that perhaps they could avoid by planning early?
I'm so glad you asked that question, Kevin. Timing is everything. The most common mistake is not to plan before the person becomes a U.S. tax resident. Once they are here, they are the U.S. permanent resident, then the worldwide taxation, those rules will kick in.
Hmm.
So if they plan to become a U.S. person, a U.S. resident, they must plan early. For example, they can plan a year earlier. They might have transferred the asset into a foreign trust. They might restructure the business ownership, or they clean up the foreign accounts before the reporting rules applied. So a little early planning can really save years of stress.
Yeah, I can imagine. I can imagine, especially with like we talked about with all the moving pieces, that getting it started early is definitely a good idea. Are there cultural or communication challenges that come up with coordinating lawyers and advisors across different countries? I mean, I know we've got Google Translate and all that these days, but it still has to add complexity, right?
I've seen families get conflicting advice simply because the advisor were using different frameworks. So part of my role is to bridge that gap. Translation, translation is not only about the language; it's about the cultures, legal structures, so everyone can work toward the same goal.
When helping families make sure both US and foreign plans work together instead of conflicting, what is your approach there? How do you make sure that that is sort of as seamless as possible?
We always start by reviewing what already exists, um, especially some documents exist overseas, like the wills, like the nominee structures, like the company records, like the property ownership records. And then we coordinate with local counsel to make sure our U.S. trust actually complements, rather overrides the foreign rules. Sometimes it means setting up the parallel plans. Sometimes it means maybe retitling the assets. And sometimes it means just simplifying, just close the accounts if necessary. So the goal is always to set up a one unified strategy that works in both different jurisdictions.
I'm always amazed when people try to do their own estate plan or try to do, God, I don't even do my own taxes. You know what I mean? Like I just rather have pay somebody to do it so I know it's getting done right and done well. I mean, do you have people come to you who have tried to do international plans on their own?
Oh yes, I've seen plenty, and people have to understand that's always a comprehensive state plan is always kind of involved different disciplines, different
Hmm.
professions, like the accounting, like the financial advisor, like the attorneys. So it's really difficult for an individual to do it all. The little things, like the mismatched titles, like incorrect translations, like misunderstood tax classifications, or outdated foreign wills, can all make the state plan doesn't work at all.
Hmm.
So something like forgetting update a beneficiary designation on a foreign life insurance policy, that one single mistake can block the entire transfer. So I have seen families lose months, sometimes years, because one piece of the paperwork doesn't match the rest of the plan. So with that international estate planning, the small detail really matters. And I really advise the people with this kind of complex assets in different countries really consult with the professional to make the plan works. Because as I said, there's so many different pieces need to put together in under a unified strategy to make this work.
Yeah, absolutely. I mean, just this conversation we've had, there's so much going on here. I just can't even imagine trying to tackle that without someone who really knows what they're doing.
Right, absolutely. It's hard to do it at all.
What gives you the most satisfaction when a client's international plan finally comes together and they realize that it's all connected smoothly?
Honestly, it's the moment when my client says, "Oh, now everything makes sense." So the international estate planning can feel very overwhelming, especially for family juggles multiple countries, cultures, and the legal systems. So seeing their relief when they understand how every pieces fit into the right place, that's incredibly fulfilling. Um, and again, I always like to say it's not just about documents, it's about giving family the clarity, confidence, and the peace.
I like that. Yeah, absolutely. All right. Well, thanks for joining us today on Estate of Mind Law, Legacy, and Life with Sunny. To learn more about protecting family wealth across borders, visit cyrlaws.com. Don't forget to subscribe to our channel and leave us a review. We always appreciate it very much. Sunny, always appreciate your time. Thanks so much.
Thank you, Kevin. See you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.